At the Table with Friends is brought to you by Friends Fellowship Community, providing the resources to help you navigate the ins and outs of senior living, regardless of where you are at on your journey. Thank you for joining us today. My name is Dana Shore. I'm the Director of Sales at Friends Fellowship Community and the host for today's episode, Experience the Peace of Knowing Your Wishes Will Be Met After Your Passing. Our guest today is Rick Boston. Rick is a lawyer and a partner at Boston, Bever, Forrest, Cross, and Sickmann. He will be sharing his valuable knowledge about protecting your assets and family after death. Rick will talk about ways to transfer property and assets at death and explain the importance of wills, trusts, and more. Welcome, Rick. We're really glad that you joined us this morning.
Thank you. Thank you. I'm glad to be here.
So if you would kind of share with us a little bit about yourself, your experience, and your credentials.
Well, I'm a Richmond boy. I grew up here, went to high school here, went to Indiana University for my undergraduate and graduate work at the law school there, and then came back to Richmond in 1971 and joined the firm that I'm still with. I've been with them for 51 years now.
Oh my goodness.
And it was an old established firm, established in 1911. So we've got a long history. And during that period of time, as you can imagine, I've practiced about every type of law there is.
Okay.
And, all during that, I've done a fair amount of probate and wills, trusts, that kind of thing. And then lately, I've been concentrating more on that than I had in the past. So that's primarily what I'm doing at this stage of my career.
So Rick, do I really need a will? And if so, what are the benefits of having a will?
Well, I certainly think everyone needs a will, and there's a lot of reasons for that. But if you have a will, I mean, you're in control of the narrative of who's going to get your assets, who's going to be the administrator of your estate to deal with liquidating assets and distributing them to the individuals that would get them. You can name the beneficiaries. You can disinherit someone if that is your choice. You can provide for specific bequests, and you can provide for instance, with the will could have a testamentary trust for your grandchildren. All those things are possible with a will, and without the will, you just don't have that avenue available to you.
So if I die without a will, who's going to get my assets and my property?
Okay, well, first of all, I mean, some people come in and think that the state's going to get your property. No, that's not going to happen. But at that point, you just have to look at the Indiana Code, and it provides who is going to get your property. So you have no choice there. And it gets a little cumbersome, and even as an attorney, we have to look back at the code and kind of figure this out. Because if you die leaving your surviving spouse and one or more children or grandchildren, the surviving spouse gets 50% of your assets. The other 50% is divided among your children. If you die without having any living children or grandchildren, then you would get 75% of the estate as a surviving spouse. The other 25% would go to the decedent's parents. And then only if you die without leaving any of your parents or any siblings alive, then the spouse would get 100% of it. But then, on the other hand, if you're a second or subsequent spouse, which is true in a lot of situations now, certainly, then it changes. And so there's no provision for if the second spouse and the decedent have not had children of their own, then the second and subsequent spouse only gets 25% of the equity in the real estate and then the personal property share. And so, you can see that if you want to provide for your second subsequent spouse or their children, you need to have a will to set that out and provide for what you really want to happen.
Most definitely. So, who will handle the sale and distribution of my property and assets if I don't have a named representative?
Well, if you don't have a named representative, which would mean you don't have a will, then you're going to have to go to the court, open an estate, and have the court name a personal representative who would be responsible for liquidating the assets and transferring property. So it's kind of out of your control then, although the court's probably going to follow your suggestions and pick somebody of your choosing, but it's going to be up to the family members to kind of decide who that person should be, and hopefully there's no conflict between family members as who's going to be in control. So again, that's why I suggest a will is a better alternative.
So, if I die without a will, does that mean that my heirs can just divide my things up amongst themselves?
Probably not. And I preface that by saying if all you have at the time of your death are just maybe some furniture and personal property, that type of thing, you can probably get away with the family just trying to agree on how that's to be allocated and hope there's no disagreement between them, because if there's disagreement, then you do have issues. But the real rub comes with real estate, because if you don't have a personal representative appointed, they're the only ones that have the authority to sign a deed. So if you've got a piece of property that belonged to your parents or the decedent, and you've got to have somebody, if you want to sell that property, whether it's now or 10 years from now, you have to go back and maybe reopen the estate to get somebody appointed that can sign a deed and convey that property to someone else, because the heirs certainly can't do that. And we do see that really frequently. I've got 2 or 3 cases going on now where people have waited a number of years. One of the children were living in the house and they just let them continue on. They paid the real estate taxes with the exemptions the way they were. And then all of a sudden they've decided, we want to sell the house. And they try to list it with a realtor, and the realtor tells them, no, you don't own the property. And then the trouble starts. So then you have a costly experience of trying to reopen an estate or open an estate for the first time and get somebody appointed to do something that could have been done if they'd had a will at the time of the death.
So let's talk about probate. What does probate an estate mean?
Probating a estate means that you're filing an application with the court to have a formal estate open. And so you would get an executor appointed or an administrator, personal representative, whatever you want to call them, to handle the administration of the estate. So the statutes provide certain rules that you have to follow with the probate process. And I might mention here that there's 2 different types of probate or probating an estate. You can have an unsupervised probate, or you can have supervised probate. The norm would be the supervised. That's what was always used for years. But in the last several years, you could elect to do an unsupervised estate. So you still have to go to the court, get an estate open, get an executor or personal representative appointed. But once that happens, if it's an unsupervised estate, you're pretty much free to operate and run the estate as you choose. And then when you're finished liquidating everything and distributing it to the heirs, you file a closing letter with the court and it's done. If you do a supervised estate, then the court has to be involved at pretty much every stage of the process.
Okay, well, that's good to know. I didn't realize that.
Yeah, and most of the time I try to put in my wills that you, as the decedent or the person preparing the will, that they wish that to be unsupervised unless the personal representative decides it should be otherwise. And you can always convert in the middle of an estate. If it's unsupervised and things start going crossways with the heirs, then you go back to the court and say, I think I need supervision, so let's switch it to a supervised estate and get the judge involved in it.
So can you take me through the probate process?
Sure. The first thing, the person would come in. After someone dies, whoever's kind of in charge of things usually calls the attorney, makes an appointment, comes in with the will, or we may already have the will in our file, sits down, we go over the assets and debts, anything related to the estate. And then with that, we prepare a petition for that person that's going to be appointed as your personal representative to sign, and you file that with the court, asking the court to open a probate estate, name this person as the personal representative. You also prepare an oath that we have them sign then that goes with that. So they have to take an oath if the court appoints them that they'll carry out their duties as the law requires. And then that's when the legal notice gets published in a local newspaper, and then you're required to file an inventory and appraisal of all the assets in the estate within 60 days from the time the estate's open. If you're doing an unsupervised estate, you're still supposed to prepare that, but you can keep it in your file. You don't have to actually file it unless one of the heirs requests it, and they just may request a copy of it. But if you're going with a supervised estate, then you have to file that with the court as part of their court records. And then from that point on, you have to file whatever is necessary to sell assets. And again, that's where the will, we normally give the executor the authority to sell without any court orders. So they can go ahead, schedule the sale, liquidate everything. If you die without a will, you get the administrator appointed, but then they have to go back to the court and ask for authority to sell the house. And the house, it has to bring, if it's a private sale, which means with a realtor or just to an individual, it has to bring the full appraised value. If it's sold at public auction, it can bring 2/3 of the appraised value. So, and then if it doesn't sell for that, you have to get it reappraised, hopefully get a lesser appraised value, go back and try it again. So again, that's another good reason to have a will and give that personal representative some authority to do things without the court being involved in the process. And so once you're finished, then you file a final accounting with the court. If it's a supervised estate, you file a final accounting with the court showing what you started with, what assets were brought into the estate, what you did with them, all the disbursements you made for utility bill, for whatever you paid, what was left, and then how that's to be distributed, to whom and how much they get. And then the court approves that, you make your distribution. Once you have a zero balance in your estate checking account, you file a supplemental report with the court saying I've carried out my duties, all the assets have been liquidated and dispersed, and ask that the court sign an order closing the estate. If it's unsupervised, then you do what you're going to do. No final accounting, nothing like that. You just file a closing letter with the court, basically saying the same thing. I've carried out my duties and so forth. And then the court sets on that for 3 months by statute. Nothing happens. There's no obligation on the executor to do anything. And then all of a sudden, 3 months later, you get an order from the court saying the estate's closed, you're discharged from your duties as an executor. So that's kind of probate process in a nutshell.
Okay. So I'm sure you hear this all the time, is if someone's an heir, they want to know how soon they're going to get their money.
You're exactly right on that. That's the driving call or whatever the heirs are. That's their burning question. And we usually tell the executor when we open the estate that you have to figure on 6 to 9 months.
Okay.
And you really shouldn't be distributing any of the assets until that period of time is up and you're ready to distribute them and close the estate out. Under certain circumstances, partial distributions can be made throughout the administration, but that's kind of rare. And it would be maybe if you have a lot of assets in the estate and they just want to get them out to where the individual heirs can invest them in whatever kind of stocks they want or whatever, rather than executor having to decide how that money is going to be invested for a period of time. So yeah, once you file that legal notice, it goes in the newspaper. It starts the claims period running. So a claimant has 3 months from that date to get a claim filed in the estate if they're owed money by the decedent. And you have a responsibility as the executor to notify each creditor in writing of the estate so that they are put on notice and they can file a claim. If, normally if you know that the decedent has debts and, they're just paid out of the estate. Once you get some money into the estate account, you just start paying the bills. But there are several of those that are disputed, or credit card debts particularly, you don't know whether they're legitimate or not.
Right.
And so usually a claim's filed there, and then you work it out with the claimant. But after 9 months from that claims period, no one can file a claim other than the government. And there seems to be no end to when they can file. I mean,
Imagine
whether it's
that.
IRS, whether it's the U.S. government, whether it's a state, whether it's a political subdivision, that could go on pretty much forever. So, but otherwise, we don't want the executor having to be personally responsible for distributing out money when we don't know whether all the claims, all the taxes, everything have been paid. So yeah, you're probably not going to get your money for probably nine months. And
Okay.
That's just kind of a guess. Some of them are longer than that. Some of them are shorter.
So once I receive this money, do I have to pay taxes on that?
So you've waited your 9 months and you finally got your money? No, you do not.
Okay.
There's, we're looking both at estate tax, inheritance tax, or income tax. First of all, on the income tax, inheritance is not treated as income, so you don't pay any income tax on it.
Okay.
Indiana did away with Indiana estate tax or inheritance tax several years ago. So you don't ever have to worry about paying Indiana anything. So the only estate or inheritance tax left is the federal estate tax, and that's the biggie. But we very rarely get into that because as the exemptions stand now, an individual has to have 12,060,000, I believe it is. It changes every year, but I think that's the current amount. And a couple would have to have double that, 24 million, in excess of that, in order to have any responsibility for paying taxes. Now, Congress has been threatening for quite a while to reduce that back like it used to be to a couple million or 3 million or whatever. That's a totally different ball game because you do see a lot of people, surprisingly anymore, that would qualify for federal estate taxes. But no, you don't. Now, if you serve as a personal representative of the estate and you're paid for that, and you're statutorily you have a right to charge a fee. You don't have to, but if you do, that's taxable income to the administrator of the estate. But as far as beneficiary inheriting, no, there's no income tax on that, and you get a stepped up basis. So if you inherit a house, maybe your parents bought that house 40 years ago and didn't pay very much for it, and if they were to transfer it to you before they died, then you would get the basis they have when you sell it, and you're going to be paying a big capital gains. If you wait and it's dispersed to you through an inheritance, then you get that stepped up basis. So when you do sell it, then it's based on that value at the time you inherited.
So Rick, can you share what is the difference between a probate asset and a non-probate asset?
Okay, first of all, with a probate asset, your will, or if you don't have a will, the intestate statutes in Indiana control that. A non-probate asset never gets into your estate, so it's not a probatable asset. Okay. So you have to recognize that your will doesn't affect those assets at all. So non-probate assets would be things that have a joint owner, joint bank accounts. It could be a beneficiary. Life insurance is a non-probate asset. Retirement accounts that have a named beneficiary would be a non-probate asset. Annuities that have a named beneficiary would be a non-probate asset. So those, you just have to make sure, since the will doesn't affect who's going to get those, that you have your beneficiaries up to date on those documents. And the other thing that people I often see fail to do is provide for a contingent beneficiary. They provide for their spouse to be the beneficiary of the life insurance, but if they would be die in an accident together, in a plane crash, whatever, or one of them die and the other one just forget to make the change, then there's no provision for when the second spouse dies, who's going to get that. So you should go ahead and put in there if you want your children to get it or your grandchildren, or to be put in trust for grandchildren or whatever, put that on whatever the non-probate asset is so it will get to the people you want. Now you can make your estate the contingent beneficiary, and particularly now because we don't have Indian inheritance tax. You used to never want to do that, but now some people just choose to let it go into the estate and distribute it according to the will. And that's how that would be handled. If you don't have a contingent beneficiary, it's automatically going to go into your estate and it will be a probate asset.
So I've heard people talk about small estate administration. Can you explain what that is?
Sure. Small estate administration would be in a situation where you may even have a will, but if you do not have sufficient assets or large enough amount of assets, you can take a shortcut. You don't have to open a formal probate estate and can move the assets a lot quicker and a lot easier. And prior to July 1st of this year, the small estate limit was $50,000. Now you could add on that funeral expenses and the cost of administration, so you got a little bit more than the $50,000. But as long as your assets, whether it was real estate or personal property, was within that limit, then you could avoid opening a probate estate and still transfer the property. If it was non-real estate, you could do it by an affidavit.
Okay.
If it were real estate, then you have to file. If there's a will, you have to file that with the court. Ask it be spread of record, not an estate open, not an executor appointed, but then get an order from the court saying that this person now has the authority to sign deeds or whatever. Okay. So if the house, if your house was only worth, something less than that maximum amount, then you could use that to transfer the real estate, and it's all over at that point. You're finished with what you have to do, and you get the job done. And so that's really changed a lot. I think, or will change a lot after July of this year, because anybody that dies after that date will have the $100,000, so it's double what you did have. So, for instance, if you had a $75,000 house and all the person maybe had was a used car or whatever, you're going to fall within that, under that $100,000. So you can do it with affidavits. Now, if you don't have real estate and you just had like not joint bank accounts, but a bank account in the decedent's name, then you could do that with an affidavit, but you have to wait 45 days from the date of death before you can file that affidavit. So the attorney just prepares the affidavit, you take it to the bank after the 45 days and present it to them, and then the bank will release the money and transfer it to whoever that affidavit shows is entitled to it. So it's a good way, a shortcut to handle small estates without getting into the costly and lengthy probate period you would have with a full-blown estate.
So are there ways that we can avoid probate?
Sure. There's various ways that you can do that. One thing is to use a trust, and but that involves a much more extensive situation where you've actually got to have previously transferred your assets into that trust and so forth. So again, you have to administer the trust, but you don't have a probate estate. But what you see people doing more is using like joint bank accounts, using TOD or POD, transferable on death or payable on death accounts, with stock accounts, with bank accounts. Again, named beneficiaries on any of those things. That avoids probate of those assets. And the other thing is, Indiana, you had these PODs or TODs for a number of years on personal property accounts and that type of thing, but it was only I don't know, maybe 5 or 6 years ago, Indiana passed a statute that you can do TODs now on real estate.
Oh,
So a lot of
really?
people are choosing to put their real estate in a TOD, and that means when you pass away, that real estate automatically goes to whoever you name as the beneficiary. So how you structure that, you would do a deed from yourself to yourself, payable on death to blank, whoever that person is,
Okay.
as the primary beneficiary. And then you can even put a contingent beneficiary. You know, if they would predecease you, then the real estate's to go to this person. So what that does for you, it doesn't actually transfer the real estate. The real estate still remains in your name. You can terminate that transfer on death deed at any time if you change your mind. There's no penalty. So when you record that with the auditor and the recorder at the courthouse, they don't transfer the property into the beneficiary's name at that time. They just note that there is a transfer on death deed
Okay.
filed. And then when someone dies, then that person, the heir to that, or the person that's going to get the property, just has an affidavit prepared, and sometimes you attach a death certificate just saying now this person deceased. So then with that, the auditor can transfer the real estate directly to you, and it's all done with a trip to the auditor's office,
Right.
and then getting it recorded. So you're seeing a lot more people using that because, I think it's much better in most cases than trying to put your real estate into your children's names or your name with your children, because you run into that tax basis issue. But
Right.
the thing that concerns me is if one of those your children file bankruptcy, if they get in a divorce situation, they now have an ownership interest in that property.
I didn't
That
think
share
about that.
will go to their credit. The bankruptcy trustee will take it. It'll go to their creditors. So the trustee can sell the house out from under you, give you your percentage of it, and any of the other siblings. But the one sibling that filed a bankruptcy, their share is going to go to the trustee and go to his or her creditors. In a divorce, anything you own goes in that marital pot. You may be able to keep it out of that 50-50 division or whatever, but there's a risk there.
Mm-hmm.
And some people, decide they want to make changes. They've decided one of these kids is a problem.
Mm-hmm.
So I want to get their name off of it. Well, you can't get their name off of it. You've deeded it to them. Unless they're willing to sign a deed deeding their share back to you, you're stuck. But with the TOD deeds, it's still in your control. They have no ownership interest. It's not subject to their creditors or to a divorce court. So those are all just different ways you can use
Right.
to avoid probate, or at least avoid probate of some of the assets.
Mm-hmm. So where do trust fit into all of this?
Okay. What you're normally talking about with estate planning is a living trust or a revocable trust. It's the same thing. It's just two
Okay.
different terms for it, meaning exactly that. That trust can be revoked. So to make it work, you've got to, and avoid probate, you've got to transfer all your assets into that trust, or at least enough that you're less than that $100,000 so you can do a small estate if your purpose is to avoid probate. But you put everything into the trust, your house is redeeded to the trust, your bank accounts or checking accounts are in the trust name, and you have to remember if you buy a new car or whatever, it needs to be titled in the trust name. And so then you'd name a trustee. It's usually yourself until you pass away or your spouse passes away, and then you have a successor trustee name.
Okay.
And so upon your death, then the trust takes over, and the trustee administers a trust according to your plan in there, and the plan can be pretty much what you'd put in a will as to who's going to get what, when, and how much. Very rarely do you see someone use a irrevocable trust. That really ties things down because,
Mm-hmm.
again, that means what it says. It's can't. I mean, there's a few instances where it can be revoked or changed, but you put that in there, you're kind of stuck with it. So those are not used to a great extent. Now, you if you do a living trust or a revocable trust, you still need a will. It's called a pour-over will.
Okay.
And you never know, that trust might be declared invalid for some reason. And so what you do in a pour-over will, you just say that if for any reason my living trust is declared invalid, or some provision of it or whatever, then it's my intention that the language in that trust for distribution be incorporated by reference into my will, so that then you get the same thing done.
Right.
It's just not done through the trust, but you're still protected. So you still have the cost of doing a will on top of the trust. So it's a more costly process, probably twice the cost of just doing a will, sometimes more, and more detailed. And so but it is an option that some people choose to use, and it does work.
So if a spouse is left out of their spouse's will, is there anything they can do to get their fair share?
Yes, there's a provision for a spousal election under the statute. So if a spouse is left out of the will, they could ask the court to award them their spousal allowance. And at the present time, that is 50% of all the real estate value. After you subtract mortgages and liens and encumbrances on it, they would get half of that, and they would get half of all the personal property. So basically half of the estate they would be entitled to if their spouse didn't make any provision for them in the will. So they're protected there. If, again, we're back to that second or subsequent spouse, then in that case, if they haven't had children together in the second marriage, then the second or subsequent spouse only gets 25% of the equity in the real estate and only a third of the personal property. So they can always elect to take against a will. Now, again, having said that, there's usually always a kind of another side. You can waive that right.
Okay.
And you can waive it sometimes in a prenuptial agreement, that, particularly in a second or subsequent spouse situation where both spouses may waive their right to claim any kind of a spousal allowance on the other's death. And you can do it after your marriage too, if both of you agree to it. But again, that's getting your spouse to agree to.
Exactly.
Usually you're offering them something. I mean,
Right.
you may say, okay, I will give you now, transfer $50,000 to you or $100,000 to you, but you have to, in consideration for that, you're going to agree to give up your spousal claim on anything in my estate. And so those are enforceable. So
Okay.
yes, it can be done.
Okay. So what if an heir does not want the assets that are left to them? Can they pass on that and let it go to someone else that is in more of need?
Certainly. Yes, it's referred to as a disclaimer. You have to prepare a disclaimer that they sign, disclaiming their share of the estate or whatever has been left to them in the will. And then it's presumed then that they died before the decedent did. So it would be like the decedent died without that person being alive. So you can't control who's going to get it necessarily.
Okay.
I mean, you'll know if you're planning this who's going to get it before you elect to disclaim your interest. But it might not go to your children. It might have gone to somebody else. So to that extent, you might not have the control to get it to who you want by disclaiming it. But we see that in quite a few instances where somebody just feels they have plenty, or at their age they don't need any more, and they'd rather see their kids, the grandkids of the decedent get it, and if they're next in line, then it would pass to them and just skip over the person that was left the property in the will.
If disputes arise between the heirs, can they do something different? Should they all agree upon something other than what the will states?
Yes, there's family agreements that you can enter into, and at least in my practice, I think these are becoming a little more common than they used to be. And so they will, if as long as all the heirs can get together and agree on something, then you can make provisions to how that's going to be, or how the assets are going to be allocated within certain limits between the heirs. So it resolves a lot of disputes in cases, and you can go on and then distribute the money according to the family agreement that's been reached.
So thanks for joining me today, Rick. I've really learned a lot from you and have figured out I probably need to be coming to see you sometime soon.
Well, I've enjoyed it. It's been a pleasure to be here with you and to talk about something that I enjoy doing. And so, I appreciate the invitation. Thank you.
Thank you. In later episodes, Bob Bever and Doug Oler of Boston Bever, Forrest, Cross, and Sickmann will be discussing in more detail powers of attorney, healthcare directives, elder law issues, various types of trust and charitable planning, among other estate planning topics. Since the 1960s, Friends Fellowship Community has been mission-driven. We have stayed true to our mission all of this time. Make sure to follow At the Table with Friends on YouTube to learn more about Friends Fellowship Community and tips for senior living.